Seminars where you've heard about it. A number of you heard from us last year. We don't want to repeat all of that, but there has been some new guidance within the last year, and so we want to touch on it. Plus, it is the gift that keeps on giving. So it's something that you really need to keep your eye on, because the excise taxes for falling on the wrong side of this can be very stiff, and there's lots of room to save a lot of money if you play your cards right. So we're going to talk about that, then we're going to hand it over to Deepa to talk about employment law issues, and to the extent we have time left, we're going to talk about a couple other things that seem to be coming up a lot that have nothing to do with any of the above. We tried to save some time for questions and answers at the end. We're fine if people want to ask questions as we go. Feel free if you feel led to do that. We'll be around afterwards if anybody wants to talk with us afterwards. So with that, John, I think you're going to get us started on the excise tax. Or is it? Or you, Taylor? You want me to take it away? Okay.
So I know that those of you who were here last year, we talked at length about the excise tax, and I know Debbie has touched on it, but we just had a couple kind of higher level items that we wanted to do a general refresher on, as well as a few more nuances that we've seen over the last year. As a reminder, it's a 21% excise tax on two pieces of compensation. One, compensation over $1 million paid to a covered employee, and then second is this concept of an excess parachute payment, and that's essentially a large severance payment. Those two types of things are what the excise tax is imposed on. Your covered employees are your top 5 employees beginning January 1, 2017. You make that analysis each year. Covered employees may change from year to year, but once someone is a covered employee, they stay a covered employee. So if I'm your CEO and I'm the highest paid, and maybe I retire and I come back later, I'm still a covered employee, so you always are going to have to keep that in mind. You probably, as time goes on, will have more than 5, so it becomes important to track, especially if you have executives who are constantly near that $1 million threshold. The excise tax is on the credit union. It is not an executive issue. It is solely paid by the credit union, and it's based on remuneration, which in short can generally be defined as wages, with the major caveat being the IRS referencing section 457F, which is the code section that applies to all of the SERPs that we prepare. And the rules under that section, it's a tax section that say the executive is taxed on an amount when he is vested, essentially. So as long as you're not vested, you don't get taxed, but once you become vested, everything is taxed immediately regardless of when it's actually paid. So if I become vested today and I don't get paid until 5 years, IRS doesn't care, I'm taxed now. That is the event that the excise tax focuses on. So once an amount is no longer vested under 457F, it's treated as paid for excise tax purposes, even if it's not actually paid. So really vesting is the key concept there, and unfortunately, in the statute that came out, as well as this new guidance that came out at the very end of last year, the IRS clarified that you look at 457F even if the agreement is not subject to 457F. So those of you who were here last year, we talked through some 6 or 7 cute, somewhat clever ideas that we had come up with of regulatory readings of avoiding application of the excise tax because those readings would kick you out of 457F. The IRS has now essentially shut down almost all of those ideas and said you only look at that event. So once it's vested, that's what matters for excise tax purposes. Bill, we had two of our leftover thoughts from last year are still viable under this new statutory scheme, and Bill was going to mention those.
Yes, we in the past year have seen we have a little less wiggle room than we would like to have had, but there are 2 things that are clearly, at least if the requirements are met, available. One, Debbie touched on. That's where she talked about the delta between where the person is being paid and the $1 million and maybe moving some of the CERT payment ahead to get within that delta. That's one thing that is available. The way that at least we write the SERPs that you guys are using, we have a lot of flexibility built into them, so you can do that. So that is one thing that makes sense. You look at the dollars, look at the numbers, and again, there can be a lot of money involved there. I know that Debbie and her group are on top of what's coming down the pike in the next year or so, insert payments to your executives, and have been working with some of the credit unions to accelerate that. So that's one thing. Another thing that's available is the use of a covenant not to compete. Now, in our group, the thought of using a covenant not to compete was first proposed by Taylor shortly after the 21% excise tax got passed, and I kind of said, might work in theory, but way too aggressive. Well, lo and behold, in the guidance within the past year, the IRS said that that is legitimate. What's going on here is if you have a covenant, let's say it's the CEO's SERP, a covenant that when the CEO leaves you, he agrees not to compete against the credit union. The object is to make that a substantial risk of forfeiture. And if it's a substantial risk of forfeiture, the money won't be earned, it won't be taxed for either income tax or excise tax purposes until that risk of forfeiture passes. In other words, the date arrives and he hasn't competed yet. Now, what the IRS said on that is that you can do it, but it has to be legitimate. It has to be real. Just a clever idea by a lawyer that gets dropped into a paragraph of the SERP is not going to save you. Is this guy at risk of competing against you? I mean, if he's 70 years old and has already built his vacation house up in the mountains of Montana, and it's clear to everybody that he's not planning to do any work in the financial industry in the future, you're going to have trouble with the IRS on that. On the other hand, if he is truly a risk, that he's going to go out there and perhaps steal some of your members or cause you some other trouble as he works for a competing financial institution, okay. But you also have to enforce the covenant not to compete. If you just say, oh, we're going to pay him the money and we don't care, again, it was something clever the lawyers put in there, that's not going to be good enough. You know, if you're getting ready to write $1 million check to somebody when you have extended payments with a covenant not to compete out into the future, wouldn't it be reasonable to see if the person is competing or not before you write that big check? The IRS certainly thinks so. And so if this is real, and we have run into some situations with some credit unions, we're dealing with one right now, where they're in discussions with the CEO about whether certain jobs he's looking at will be considered competitive. So if this is real and enforced, that's a good way to keep the excise tax down and in the process to defer the income tax to the executive.
Bill, just a quick question,
yes.
Just a show of hands. Who has non-competes at their credit unions? Okay.
In an employment contract, typically.
Right.
Right. Yeah, they're common. Well, it didn't look from the hands like they're common in the employment contracts, but I am talking here in the SERP. And the penalty in the employment contract is that you would bring an action against the person to enjoin him from taking that new job. The penalty in the SERP is that if he competes, he doesn't get the SERP payment. That's serious. That'll get somebody's attention. So that's the kind of covenant not to compete we're talking about. One other thing before I pass it back to Taylor, unless Taylor's going to lateral it to someone else. If you take, well, as I mentioned a minute ago, when we design SERPs for you, the way that we do them almost all the time, with this group at least, is a method which gives you maximum flexibility. If you're going to take the covenant not to compete approach, you're going to lose a lot of that flexibility when you build that into the SERP. So that's just one thing to remember about it. You're going to be locking down some of your options if you decide to take that approach.
Question of non-compete. The geographical area has to be reasonable. So how far can you do that?
Okay.
Nationwide, statewide,
okay.
regional-wide, whatever, because if it's too broad, it's not fair.
Well, that's a very good question. Let me approach non-competes in two ways. First, there's the employment type of non-compete. That's governed by state law, and every state's going to be different. But there's the general theme you mentioned, that they have to be restricted in both time and geography. Usually, if you keep it within the state for a CEO, you're going to be okay, at least within the geographical boundaries of the credit union. But that's going to be a state issue. It's going to have to be resolved state by state. Now, for the covenant not to compete for the SERP, now we're into federal law. And federal law also says that it has to be reasonable, but there's not a body of law that's backing that up. So that's still a bit open. We kind of have a tug of war oftentimes with a board when we're doing this. As lawyers, we want to keep it as tight as we can because it's more defensible that way, where the board is saying, oh my gosh, no, we might be here in Texas, but if he goes out to California to work for another credit union, we care. That's going to hurt us. That's getting kind of aggressive to make one like that for a SERP, and it might not at all be allowable under Texas law. I just don't know what Texas law is on that.
One of the things that I've heard from executives when we propose this is they're nervous about leaving it at risk and putting it out in the future because they don't know where taxes will be. Their personal tax will be. Stretching it out over a number of years. So it has to be at risk, and then who knows whether their personal tax rate will be as favorable as it is right now. So
good point.
Some of the executives that have large SERP payments, we put it on the table, and they're like, a bird in the hand. I know what my tax bill is going to be.
And not just on the taxes either. A bird in the hand, cash. Versus a promise of cash. Yeah.
So what about the issue of the deferring it and having it have to be a larger payment?
Taylor, do you want to address that?
So Debbie's referring to a rule that we've dealt with recently under these proposed regulations where if I have a payment coming due on January 1, 2020, I can move it to a later date, but it has to be at least 2 years out, and we actually have to increase that payment by a 25% increase. So the problem with that approach, if we're increasing payments by 25% to save on a 21% excise tax, we're just spending more money. That is not an issue where if we draft the covenant not to compete type arrangement in the first place, but to Debbie's point, executives are probably going to push back on it, and it simply just may not work in the market, where if CEO says, well, I can go to this credit union and not have a non-compete, why would I go to this one? So that's the drawback there. There are two other items we just wanted to quickly touch on for the excise tax, and then I want to send it to Deepa. Last year we were hopeful that there might be some grandfathering for arrangements currently in place. The IRS has now explicitly said no, there is not. And then the final and important piece is related organizations. I know we've dealt with some of you who have QSOs who provide services and that are either wholly owned or partly owned by the credit union. Pending that level of ownership, it could be considered a related organization, and if you're funneling money through the QSO to one of your covered employees, that money is going to get picked up as well, even though it's not paid by a tax exempt, and the QSO could be liable for a portion of the excise tax. So that's just kind of a couple things to keep in mind there. And then we had some next steps here of tracking your covered employees and just generally being aware of when these monies are going to be coming due in the future, and determine whether there's anything you can do to avoid the tax. And I'll pass this on to Deepa now.
Hi, everyone. Can everyone hear me okay? Okay, perfect. All right, so I'm going to start talking about some employment law issues. Keep the questions coming as you have them, please. We don't want to make this super formal discussion and me just talking at you. So, all right, let's start with hot topic number one. And the topic that we heard was important for y'all to hear about or had questions about is pay equity. So one of the statistics that y'all might hear when it comes to pay equity, and I've heard many different numbers, different statistics on this, but this is one of the ones that I see cited quite often by government agencies, is that US women on average earn about 80 cents per each dollar earned by men. So pay equity refers to the idea that states are trying to implement laws where companies are not able to discriminate based on sex when it comes to pay. So states and legislatures are trying to make sure that companies are fairly paying their employees regardless of sex. So the main question is, are similarly situated men and women earning the same amount? And similarly situated, as you can probably guess, has a lot packed into it because it's hard to determine sometimes who is similarly situated. But that's the question. If someone is working in the same position as someone else, they're doing the same things, they have the same amount of experience, they have this, similar backgrounds, they work in the same city, if they're pretty similarly situated in their roles, are they being paid about the same? And if not, why is there a difference there? So again, if you have a male employee and a female employee who are similarly situated, you just need to know why there are distinctions between their pay. So things you might want to do to ensure that you're paying your folks fairly and equitably is to audit your compensation of your employees. Look through what you're paying everyone and look to see why there are differences between similarly situated employees. Also train your managers. Make sure that managers know why they're making the pay offers that they are, and that they're regularly auditing their own documentation to make sure there aren't discrepancies that can't be explained. Also consider having compensation scales. So having a scale that tells you for this kind of role in this geographic location, this many years experience, where here's a range of compensation that we might offer to someone in that role. So when you have that kind of a compensation scale, you have less discretion to stray outside of that scale. And again, the biggest thing here is just regularly auditing. If there are different people making compensation decisions, there might be a lot of variance between what folks are earning. So you just want to make sure that you're auditing that to make sure that there's no trends or nothing you can see that's discernible where women are regularly earning less than men or anything like that.
And we were actually talking about this yesterday. There's some really prohibitive penalties here if you run afoul of these pay equity rules. We've got a couple of our clients have run afoul of them, allegedly.
Absolutely, absolutely. So for example, if you find that there's a discrepancy here, that women are in fact earning less, and you continue with that pay method, there could be punitive damages, and folks are really going after employers who know that there's an issue here, know that there's perhaps some kind of discrimination occurring, and they're not doing anything about it, because at that point you're knowingly having this inequitable pay program. Yeah. Yes. Yep. So it applies even if it's an internal promotion as opposed to bringing someone in from the outside. So if, for example, you're promoting someone to a position and there are other people already in that role, you want to make sure that you're looking at the pay of the other folks in those roles to see if, again, there's any lack of equity there. And I'm not saying everyone has to be paid the same, but you need to have objective reasons as to why they're being paid differently. So maybe someone has 10 extra years of experience, or maybe someone has a degree that the other person doesn't have. So if you have these reasons that you've thought through, you can pay people differently, but you need to make sure that you've actually just gone through the analysis. All right, so that kind of leads us into hot topic 2, which is inquiring about pay history. So what states and localities are really concerned about with this is that women, if they're earning less, they're continuing to earn less even when they go into new jobs. Because if an employer asks, what were you earning before? Okay, and then let's talk about what you were earning before. We'll match that, or we'll raise it a little bit. But you're perpetually having this lower salary, lower compensation if you're basing it on the history of the person, what the person was making before. So about 17 states and 19 localities have some form of a statute now that actually prohibits employers from asking about salary history of any employees. So you can't ask, hey, what are you making currently? What were you making at your last job? You can't ask about salary histories. So it's definitely a trend, rising trend. More and more states are considering this kind of legislation to make sure that this pay inequity ceases. And there are
salary for the making, correct? It's not history.
history, right. Right. So you can ask them what they would like to make in this role if they get it, but you can't ask them what they're making in their prior job. And this is a matter of state law, so the state laws are obviously going to be phrased a little differently, but that's the general idea, is that you can't ask about the history. So one of the first states that kind of made the news a lot on this topic is Massachusetts, and it went into place last year. And it said that employers cannot request salary history information. They can, however, confirm prior history if it's volunteered by the applicant or if an offer has been extended. If known, previous pay cannot be a defense to a pay discrimination claim. So for example, in Massachusetts, if it comes up from the person, him or herself, then you can discuss it, but you can't ask about it until later in the hiring process. And then, of course, you cannot use that as a justification to pay someone less. I did look into Texas because I know we're here in Texas, so in case that's important to any of you. In Texas, there's no specific salary history inquiry law, but they do have a general wage discrimination law saying that you can't discriminate based on sex or race or any of these other protected characteristics when it comes to paying wages. So there's different things you can do here when it comes to inquiring about salary histories. The safest option is to not ask about salary history, but of course, since it's not a nationwide issue and it's not even in half the states, you might want to continue with your practice of asking salary history, of course, making sure that you're still following pay equity laws and you're not discriminating based on that salary history. But safest bet, stop asking about it, because I think it's over the next 4 or 5 years, it's only going to be a longer list of states and localities that prohibit that kind of inquiry. Option 2 is to ask the questions if you're in a state that doesn't yet have the statute and just keep watching the legislation. And ultimately, like I said, just don't discriminate based on sex or any other protected class. So even if you get that information from someone, don't use that as the basis to pay them a whole lot less than somebody else if there's no other reason to distinguish. Okay, hot topic number 3 is sexual harassment. So I know everyone here has heard a lot about the Me Too, hashtag Me Too, the whole movement in the last couple of years. And so we've really seen an uptick in terms of sexual harassment questions from employers and from clients. So not necessarily that we're seeing more claims, but we are seeing more questions from employers. So I think that the good news is that people are more attuned to this issue. They know it's going on in workplaces all over the country. And so employers are really stepping up in training their employees, training their managers, and making sure they're watching out for their employees. So there are state laws that come into play when it comes to harassment. California is one of the big ones. They've had anti-harassment statutes on the books for a while, and they're really kind of at the forefront of making sure that employees know what their rights are and that they're protected when they're at work. So in California, for example, you do have to train, if you have 50 or more employees, you have to train your supervisors every 2 years. And there's very specific requirements as to how that training is performed, but you have to give anti-harassment training to all of your supervisors every 2 years. And you have to provide training within 6 months of someone becoming a supervisor. So if someone's promoted, they have to receive that training within 6 months, and then every 2 years after that. And California is actually expanding out to this training has to be provided to all employees starting in 2021. So it's not just going to be supervisors, it's not just managers, but they're spreading that out to everybody. New York, if anyone's in New York, they are also on the recent list of states who they've passed statutes that require training, require postings in the workplace, require specific complaint reporting mechanisms, investigations as to what you do when you receive a harassment complaint. So New York and California are really, again, at the forefront of having very specific statutes on dealing with sexual harassment. So again, even if you're not in a state that has any requirements, I highly encourage you to train your managers and make sure that they know what harassment is, make sure they know what is not allowed in the workplace, and also make sure that you have policies posted so that your employees know what harassment is and what's appropriate in the workplace. And then have complaint reporting procedures. Make sure your employees know that if they see something or they hear something, they need to bring it to you or to the HR director, or whoever your point person is, because ultimately you want to know internally if there's an issue before someone goes to a lawyer, before someone goes to the government, before someone goes outside of your company to get this fixed. You want them to come to you so that you can fix it. Yeah. Yeah, so it's going to depend on the state statute, but certainly if anyone is actively working, they're on the board, they're doing work for your organization, even if they're not an employee per se, there's going to be training requirements for those folks as well.
And it's very important to have these reporting procedures and investigative procedures in place. This is all about managing risk, right? So we're not just managing financial risk, we're also going to manage reputational risk and cultural risk. So all of those boxes are checked with the sexual harassment and Me Too. I'm always surprised when I talk to clients and I find out they don't have these policies in place, whether it's an ethics policy or a whistleblower policy or a sexual harassment policy. And if you don't have one of these policies in place, it really can hurt you in a lawsuit, because one of the things you try and show is, well, we try and investigate and remediate and address the issue. But if you don't have a process in place, it could really have some big liability issues. Yeah, absolutely. Absolutely. So in a sexual harassment case, actually, that is the #1 defense that we use, is to say that we had a policy in place that very clearly prohibited harassment, that we had a complaint reporting procedure in place, and that this employee may or may not have used that reporting procedure. So we have to have that complaint procedure in place to be able to show that, hey, this employee knew this was here, didn't use it, therefore we did not know about this harassment, couldn't have done anything about it. That's the defense. So you really do have to have those policies in place, and not just dressing, right? Not just window dressing. You want to actually follow, implement, enforce, because again, when you don't enforce is when people go to the EEOC or the government agency, and then it becomes a lot more work for all of you. All right, next hot topic is LGBTQ coverage of Title VII. So y'all might have seen this topic in the news recently, because the Supreme Court actually just heard a couple of cases last week. Actually, it was 3 cases, but 2 were kind of grouped together, and the other one was separate. So, but they're all concerning LGBTQ coverage of Title VII. So for those of you who don't know, Title VII prohibits discrimination, harassment, retaliation, and it's sex, race, national origin, I'm just blanking, but yeah, religion, yeah. So you're basically not able to discriminate based on those protected categories. And so the question with these cases is LGBTQ, sexual orientation, and gender identity, are those things covered by the term sex in Title VII? So sexual orientation is not currently listed in Title VII. Gender identity is not listed in Title VII, but some states do have that protection. So California, for example, does prohibit discrimination based on sexual orientation, gender identity. Other states have similar protections. So there are some state issues, but under federal law, that's not yet a protected class. So these 3 cases that were argued last week before the Supreme Court, 2 of them involved 2 men who argued that they were terminated for being gay, so sexual orientation-based discrimination. And the 3rd case involved a gender identity case. So it was a person who was expressing as a female and believes that she was terminated for that. So keep your eyes out for this one, because there will be a decision that'll come down soon. Everyone's really interested to see what'll happen there, because currently Title VII cases, the courts have interpreted Title VII to cover gender identity. So if you discriminate against someone for not acting the way you think a man should act, for example, that could be a Title VII covered claim, because it's because of sex, but sexual orientation is not currently covered.
So, like I said, the ultimate question is, does Title VII's prohibition of sex discrimination encompass discrimination based on sexual orientation or gender identity? So this is a very interesting case. I'm very excited to see where the court comes down, so do keep your eyes open on that one. All right, hot topic 5 is marijuana in the workplace.
No, a fun topic.
We were actually talking about this at dinner last night. Lots of folks from Colorado who deal with this pretty regularly. So as you all know, some states have legalized marijuana, some on a medical basis, some on a recreational basis, and so it gets a little sticky because it's still illegal under federal law. So a lot of employers say, well, people are allowed to smoke here recreationally, then they come to work and they're high, or they fail a drug test. What am I supposed to do here? So again, it's a matter of state law, so please make sure that you are aware of what your state law is if you have medical marijuana, if you have a question about that, or give us a call. But you can typically still take action, adverse action against an employee if they fail your drug test. So a lot of the state statutes will have a specific statement in there that says, okay, you can still follow your drug testing policies, and obviously if someone is high at work, that's also would be a legitimate reason for separating. But of course, it's not just the legal side on this, it's do you want to take action, right? Because if it's legal, who knows, half of your workforce might be smoking pot. So what are you going to do if half the people fail your drug test? Are you going to wipe out all your employees and have to rehire? And so you have to think through some of the ramifications of how you're going to enforce your drug testing policy. But like I said, a lot of state statutes do allow you to take that adverse action if you need to. So state distinctions, Colorado statute in particular reads that nothing in this section shall require any employer to accommodate the medical use of marijuana in any workplace. So they are specifically carving that out, saying, you know, you can still take action if they fail your drug test. Arizona's is a little bit stricter. I don't know if there's anyone from Arizona here, so I don't want to get too far into it, but basically they're saying you can't take adverse action against someone unless you have specific reasons. So unless you're going to lose a monetary or licensing related benefit under federal law, you can't take adverse action against someone if they fail your drug test, unless again they're high while at work. So there could be a danger if they're actually high at work, but if they merely fail the test and they don't appear high at work, which is a really difficult call to make, then Arizona is pretty strict that you should not take adverse action. I also caution you when it comes to medical marijuana or recreational marijuana, well, not recreational, but medical, there's a disability issue here. So in Massachusetts, the medical marijuana laws are silent on allowing or restricting workplace discipline for medical marijuana use, but the courts have said that if you terminate someone immediately for failing a drug test for using medical marijuana, you may be running afoul of the disability protections because so the courts are saying you need to engage in the interactive dialogue with someone who's using medical marijuana because you need to determine if you can accommodate medical marijuana use for a disability. So it crosses over into the Americans with Disabilities Act and state disability laws when it comes to medical marijuana. All right, I have a few just topics I'll touch on really quickly. NLRA, the National Labor Relations Act. So this is not just for unionized workplaces. A lot of people, when they hear NLRA, they kind of tune out because they think it's for unionized workplaces, but that's not the case. Applies to everyone. So some of the topics that we get questions about a lot. The first one, pay discussions amongst coworkers. Oh my gosh, I heard these people talking about their pay and I'm going to fire them or I'm going to discipline them because why are they talking about their pay in the workplace? So the National Labor Relations Act applies to protected concerted activity. So the NLRB, the board that enforces the act, would say that these two people were discussing workplace conditions, and this is for non-management, right? So These two non-management employees were discussing their pay because they were engaging in protected concerted activity, trying to make sure that they're being paid fairly. They're discussing a workplace condition. So generally those kinds of discussions are okay. You should not discipline folks or take action. Now, there's obviously gray areas there, because if someone has accessed confidential pay information and is of someone else and then is discussing that information, that's a different issue. But if they're just discussing their own pay with a coworker, very likely that will be okay. So be cautious before you proceed on any kind of action with those kinds of folks. The next one's social media. A lot of questions about what do we do if someone posts about work, something work-related on social media, on Facebook or Twitter or whatnot. Again, if that's protected concerted activity, if that is discussion of a workplace condition, that's very likely allowable under the NLRA. Now, again, if they are exposing proprietary or confidential company information, client information, anything that is confidential or internal or should not be posted, then that could be grounds to discipline, but you want to be pretty careful on social media as well.
Would this also protect like free speech for people at work? For example, if I go on the Twitter or the Instagram, you could probably tell I don't have social media accounts, and say my boss is a jerk, would that be protected?
Yeah, so that would be an NLRA protected for sure, because what the board will say is, okay, they're friends with other people from work, so what they're saying is you're probably going to make that comment, other folks from work could comment, so it's this water cooler talk, but online. So if you're expressing concerns with a condition, which my boss is terrible, my boss yells at me, I don't like my boss, those kinds of things could be expressing workplace conditions. So now if it gets to the point of being defamatory, or you're just completely saying defamatory statements, then that might cross the line into being a disciplinary issue. But if they're complaining about a workplace condition, it could very well be protected. And then we're looking at recordings at work. So again, this is something that comes up a lot of times with investigations. When there's someone being interviewed in the context of an investigation, they might try to record. This is a matter of state law. So some states are single consent, some are double consent, where both people in the conversation need to consent to the recording. Georgia, for example, is a single consent. So what you can do if you're worried about an employee recording in the workplace is to let them know that we don't allow recordings in the workplace. We ask that you not record here during this conversation. Now that might raise their flags a little bit to say, oh, well, should I be recording this? So you might. It depends on how you think that conversation is going to go. But that's about the best that you can do. And then, of course, just be careful on what you're talking about so that there's not a concern as to what is being recorded.
How would this affect if your employer gives you a cell phone or an iPad and you're sending text messages? Would the employer be able to confiscate your iPad or your iPhone? Yeah,
absolutely. So if it's the employer's technology, your iPad or your phone, the employer's phone, then you should have an IT policy in place that says you're going to monitor, you're reserving the right to monitor all of these items, and that you can take those items at any time to review them. So you just want to make sure you have a policy in place that you can then point to and say, hey, we need to see your iPad. Be careful with that. You want to make sure that you're not discriminating in who you're asking to review their materials or reviewing their technology. But certainly, if you own it and you've told them that you're going to look at it, you can look at it. Yeah.
Does that also apply when you're paying for the service?
When you pay for the service, yeah. So that's a little bit touchier, right? So if I have my own personal phone, but I have a program from my employer on the phone, generally you can say that you'll monitor that program. So if they have your email server or some other work-related app on the phone, you can review that. But if it's their personal phone, you're very likely not going to be able to review the other items on the phone that don't really belong to the employer. All right. We are back to the benefits, folks.
Good. Me first? Okay. I think we just have a few minutes, so I'm just going to touch on one thing that was in my hot topics. Health coverage. When you're having a severance, and here I'm thinking primarily of a friendly severance. The CEO is leaving and you're trying to cut some kind of package when he leaves. He asks if you'll cover him and his spouse until they reach Medicare age. Compensation gets together, thinks about it, says, yeah, that's reasonable. Sure, we'll keep you on our health coverage till Medicare age. No, you don't want to do that for three reasons. One, COBRA already provides protection for 18 months. If the person's, say, only 60 years old, that's not going to get them to Medicare age, but that is what's provided. And if you go beyond that, we're in kind of a changing area of the law, but it's going to probably be viewed as discriminatory, and therefore there are going to be tax implications. It's not the worst thing in the world that people have to pay taxes, but that's one problem. Second problem, and to me this is the biggest one, the insurance coverage. Whether you're self-insured or whether you have an insurance company that's providing the coverage, that policy says who the insurance company is going to be liable for. And that policy probably says regular full-time employees. So when this person's been gone for 2 years, is he a regular full-time employee anymore? No. So cancer or something very expensive like that comes up, starts generating a couple $100,000 in medical claims. It's going to get audited by the insurance company, and they're going to say, sorry, we don't cover that. And here you are between a rock and a hard place. You promised it, but they're not covering it. I've had this happen to several employers, and it's always been in 6 figures, well into 6 figures. So you can't do that. Be careful with it. Now, the third thing that kind of as an afterthought I was going to say on this is a lot easier now than it used to be. You have COBRA for 18 months. You got the Obamacare exchanges. So you can help the person financially. You can pay for the Obamacare exchange coverage, or you can pay for the 18 months of COBRA coverage. That's reasonable, I think most people will feel. So just be careful. It's so easy to say, yes, we'll provide you medical coverage, but you can get into big trouble doing it that way when you could reach basically the same point doing it another way. Since we're almost out of time.
I also wanted to speak to the board members out there. How many boards have an audit committee, a separate dedicated audit committee? Okay, so 5 or 6. Of course, one of the more important functions that a board has is oversight. As I mentioned before, we're managing financial risk. We're managing cultural and reputational risk. And being a credit union, I think the financial side is probably pretty important, right? We want to make sure we get that right. And that's not just credit unions, but it's also private corporations tend not to have this function set aside, to have a dedicated committee members that are at a board of directors to look at the financials and to do oversight. Because the important things that we have here on the audit committee side is the internal control over financial reporting. We also want to look at enterprise risk. Are there kind of black swan issues out there that may be an issue for the credit union? And we also want to make sure we comply with legal and regulatory rules. Now, I understand there are smaller credit unions that may not have the resources to put people on the committee. But what you can do is look to your supervisory board. Supervisory boards are probably going to have a CPA or 2 on them. They can satisfy this function. If you don't have a supervisory board, well, then you can look at an outside third party to come in as an independent set of eyes, just as a check to make sure on the financial reporting side, everything is straight. It's very difficult for a board to do this because they're really responsible for the entire oversight of the organization. So to take this out and have a specified board to look at it is very important. So it's something you should certainly consider. Even if you're a smaller credit union, there are ways to address this. The other thing I wanted to talk about briefly is policies, board-approved policies. How many people have a code of ethics or a business code, you call it? Good. Okay, so about 40%, it looks like. This business code of ethics especially for your officers, is something you should certainly consider if you don't have. And if you do have it, just to check up on it once a year is again, a very important practice. Because what this is looking to avoid conflicts of interest or the appearance of a conflict. Certainly if you have officers who are involved in other businesses outside of the credit union. You want to know about that. And I would recommend, if you do have a business code or a code of ethics, to have the officers at least once a year sign a statement, a simple statement that says, yes, I've read the code, I comply with it. The reason we want to have this on file is if anybody comes in and wants to look at your practices, as we were talking before with Deepa, we can point to it and say, yeah, we have a code of ethics, and we give it to each of our new hires in each of our offices, and maybe we have a training session once a year. And we also have this piece of paper that says, yes, they've read it and they've complied. So it's this due diligence that will protect you to the extent you can be protected for something like this, if the regulatory people come around to look at your practices.
And I think we're pretty much out of time, so we can, if anyone has any ACA questions, we can talk about that later. But want to keep things moving here. And if you have any other questions, we'll be around and lingering, so and are happy to discuss. So thank you very much.